by some respondents, namely Juliana Cherera, Irene Masit, Justus Nyangaya, and Francis Wanderi, who appear to be supporting the petition. These 4 respondents have been allocated 1 hour to share among themselves. That gives to that 15 minutes each if they are represented by different counsel. Then parties in opposition to the petitions, we have identified IMBC together with the chairman, Wafula Chebukati, and we have allocated them 3 hours to share. William Ruto and Rigathi Gachagua, they have been given 3 hours. The Attorney General will be given 30 minutes to respond. According to the rulings that we have delivered, we admitted 3 amici curiae. They will not be given time to make oral submissions. According to the rules of this court, we will rely on their briefs, which are on record, unless the bench wishes to raise an issue for clarification by them. That will take us now the 2nd day of the hearing. We are hoping the 3rd day, which is Friday, we will hear a rejoinder. We'll give the main petitioner in petition number E005 of 2022, Raila Odinga and Martha Karua, 1 hour to respond. Petition number 001 of 2022, John Joroge, will have 15 minutes. Petition number E002 of 2022, Youth Advocacy Africa, 15 minutes. Petition number E003 of 2022, 15 minutes. Petition number E004 of 2022, 15 minutes. And petition number E007 of 2022, 15 minutes. And petition number E006 will also have 15 minutes. As you will also have noticed, we have given a comprehensive ruling on the applications that were filed seeking discovery, various discovery and scrutiny. According to the order that has been issued, we are expecting a report that will be tabled before this court for consideration by Thursday afternoon. And if there will be issues arising from that report, we have agreed to give the main petitioner 30 minutes to respond. And because they filed an application for discovery, so was Youth Advocacy Africa and Mr. Kerif, they also filed an application for discovery. According to the issues that they were raising, the Youth Advocacy will be given 20 minutes, and Kerif, who was seeking 1 issue, will be given 10 minutes. The IBC will be given 30 minutes, and William Ruto and Rigathi Gachagua will also be given 30 minutes to respond to the report that will be filed if there will be issues arising which they will wish to respond to. That is the time allocation. Due to the time constraints that we have to determine these election petitions within 14 days, you will appreciate also the filing was tight within 7 days. This is dealing with information or evidence from all over the country. The framers of our Constitution decided that they will give 14 days. It has been done before, and we hope to do it also this time. But we will also seek your indulgence when you are allocated your time, you will adhere to the time. We also developed some ground rules as a court where we are requesting that parties and advocates will observe punctuality, the time that is indicated for us to start the proceedings, and the time allocated to them on the screen. We will also, this is an old practice, that we will continue to be respectful of the court, our personnel, and also to respect each other, adhering to the rules of this court. We also are obliged to state that we expect parties to conduct themselves with decorum to preserve the dignity of the court and the proceedings, while bearing in mind the provisions of Section 28 of the Supreme Court Act. We are also reminding ourselves that these are judicial proceedings being conducted in court, and therefore discussing the merits of the case by the parties or counsel outside the court is not permitted. We still have the power under Section 28 of the Supreme Court Act to cite such parties who are in violation of the provision of the law. We also like to remind you that courtesy must be observed at all the time. The court will not tolerate offensive language. We like to repeat about the time allocated due to the time constraints. Once a party has exhausted the allocated time, the microphone will be switched off. We also wish to state that if there is time that is unspent by the council, the time belongs to court, so we will not allow anybody to donate, but revert it to the court for the court to share it out, according to the court's generosity or lack of it. Due to the limited timelines, there will be no extension of time, so please let no one ask for extension of time. We are dealing with the submissions that have already been filed. We have been painstakingly reading those submissions. Therefore, we wish parties to just focus on the key issues that they would like to highlight. Parties are therefore urged to focus on the pertinent points of their case to save on time. We always like to remind parties cell phones must be switched off or on silent mode. During the hearing, unnecessary movement or disruption when the court is in session is discouraged. However, parties or counsel or even the bench are, however, permitted to take health breaks during proceedings as the need may arise without disrupting the continuity of the submissions. And during these individual breaks, the proceedings will proceed. Even if I want to walk out, don't think the proceedings have stopped. They will proceed. The media present, we have already issued the media guidelines that must be observed all the time. Given the immense public interest in the proceedings, we have allowed media houses to run broadcasts, live broadcasts to enable Kenyans to follow the process from any part of the country and even beyond. We urge members of the public to follow the court proceedings from the comfort of their homes or offices through their television and stream broadcasts without the need of coming to court physically. This is particularly informed by the reality that due to the limited space within the court premises, we can only accommodate a limited number of persons to attend the proceedings in person. Consequently, we have restricted physical access to the court premises only to the persons who have been accredited as parties, counsel, or court personnel. We will also urge the counsel, when you're making your submissions, any references made to the material. You can see the voluminous nature of the files. They are still in our chambers. Please, we ask you to specify the bundle and the page that you'll be referring to for ease of reference. If there is any electronic presentation to be made, we would kindly request that it is provided to the registrar of the court 30 minutes before the commencement of the day's hearing. As I have said before, court number 1 has been prepared as a spillover room to accommodate parties and the advocates. We are also reminded by the Ministry of Health to continue reminding ourselves of the COVID-19 protocols and regulations which will apply in the course of the proceedings. We urge parties to cooperate and comply with these directions. I think that is all from the court.
Chief Justice, Deputy Chief Justice, Your Leadership, my lords, judges of the Supreme Court, I think there is one matter, Chief Justice, there is one issue that was raised by my colleague, Professor Gidu Muigai, regarding the correct team of lawyers legitimately representing the Independent Electoral and Boundaries Commission. This honorable court is aware that there is an application which was filed, I believe, fairly late last night and was responded to on that very issue. And I think in order to save time, I would suggest that perhaps the court considers that issue and gives directions in a ruling, my colleague, Professor Githu Muigai, and my good friend, Karoli Kamau, have filed a set of pleadings on behalf of the Commission. Issa Mansour has filed a set of pleadings on behalf of the Commission. As far as I am concerned with Issa, as I indicated, we rely on a resolution by 4 of the 7 commissioners. We have stated in our pleadings that we are legitimately representing the Commission. Our colleagues have filed the pleadings on the basis of instructions, I believe, by the CEO, who we say the CEO implements instructions from the Commission. The Commission is a corporate entity. In the absence of consensus, decisions are by majority. But because all these things are actually in the pleadings filed, all I'm pleading is that this Honorable Court considers those pleadings and gives its directions or ruling so that tomorrow we are able to move on without wasting the time of this Honorable Court. I thank you.
May it please you, Madam Chief Justice, and the honorable members of the court, I would like to set the record straight. IEBC filed an application on the 29th of August 2022 seeking to strike out pleadings that were purported to have been filed by one Issa Mansour. That application is pending. We take the view, 2 reasons if we need to make the argument. First of all, we have a notice of appointment of advocates that predates the entry of Issa Mansour. Best civil practice would have required, if a legitimate change of advocates was to be made, for a notice of change of advocates to be filed. No such action was filed by what I consider a very, very competent firm of advocates. So there, in our view, there must have been collateral purpose. Secondly, it is not the work of the commissioners of IEBC, whether in majority or in minority, to procure any services. That flies totally in the face of the procurement law in this country. As we sit here now, the 4 who purport to have procured have committed a criminal offense and should be treated as such. So, in my opinion, what I understood my lady and the court to have said earlier in your ruling was that IEBC was properly represented by its advocates on this table. However, the 4 individual commissioners who are now cited as respondents but who are supporting the petition will continue to enjoy the very distinguished services of my senior learned friend, the Honorable Paul Mwita.
Your Ladyship, Madam CJ, there is something that is likely to be lost as my 2 learned friends are fighting. And it is so important, it could compromise really the fairness of the hearing which you have endeavored with so much effort to craft a way forward. It is this. 8 petitions were filed against my client within the 7 days cast in stone in the Constitution. It is the first time in this republic that 8 are filed. In 2013, there were 2. But because of ingenuity of this side of the court, we now can file very many, all intended for the same purpose. That aside, I burnt midnight oil, filed my response within time. Then comes the group of 4 commissioners. On 26th August, they have filed a response to the petition. They are filing this under the pretext they are respondents. They file a response. It is not a response. It is a new petition. There are new claims, new grievances, new grounds for nullification of my client's electoral victory.
Senior counsel.
Yes.
I think a ruling was delivered on their participation as respondents.
If you could just allow me 1 minute.
What we are addressing is whether they should be represented by lawyers or by IBC.
I was dealing with the response that they have filed. And that is the point that I think my learned friend, Githu Muigai, was alluding to. Will that response still be on record, or are they limited to the affidavits that they had filed and which have been allowed? Because if the response is also part of the record, a response filed or a new petition filed outside time, I do not know whether I need to respond to it and whether it will be admitted by the court, notwithstanding the strictures in Article 140. I hope my...
We've gotten you, Senior Counsel. What we are dealing with is the application of whether we should allow counsel to represent the 4 commissioners. As you can see, the 2 factions are insisting they are representing IBC.
And in the mix of it is that response that has been filed by learned counsel Paul Muite's team.
We will retire to consider that application.
Please.
Which was, I think, filed out of time. So
yes, that
last night.
Is filed out of time.
We'll consider it and come back with a ruling.
Correct.
Yes.
That's number 1. Number 2, again, something which may be lost out. When I look around me, my colleagues, each representing a party. And as you said, some could be secondary petitions. They each have, under the guideline you give, 4 lawyers each. Very carefully, I did.
It's only the main parties who have 4 lawyers.
All the petitioners are main parties.
Okay.
All the petitioners are main parties. Say, for example, petition number 1, they have my learned friends, 4 of them. And the same goes for each petition. I don't know why the noise is being generated. I can see a battery of governor. It's each 2-2. Oh, huh?
Mr. Ngatia, the other petitioners have 2, not 4.
Oh, very well.
So you really have no reason to complain.
Thank you so much, my lord. Nonetheless, actually, that makes my work much easier. Each has 2, there are 8, 16, all against nullification of 1 person. And then that 1 person, you limit him to 4 lawyers. I appreciate, I'll be the first one to say we are living in difficult times. But surely it will be very difficult for me, and I say this in all fairness, to be able to master a defense against all the 18 lawyers when all we have is a team of 4. Let me say the last thing, Madam Chief Justice, because your fairness is legendary. The total time given my learned friends, all the 8 of them, is 8 hours. I have been allowed 3 hours. I would have requested you, Madam CJ, if there's any way you could, allow me at least half the time that my opponents have, so that I could at least be able to master a defense in relation to petition number 5, the primary, and the proxy ones, the 6 of them. That is all.
My lady, if I may, if I may have your indulgence for only 1 minute. I noticed that my lady observes that this application was filed out of time, and we admit that that is so. But the reason is that it is not one of the applications contemplated under the rules. Issa Mansour, Esquire, filed his papers on the 26th. We did not expect that there would be another petition filed in the guise of a response, because what the 4 commissioners have done is to file a fresh presidential petition outside the constitutional timelines. We agonized as to what we ought to do in the circumstances, and the only thing open to us was to make the application on the 29th. So we beseech you that if you find that it is out of the normal timeline, you nonetheless grant us an extension of time, because resolving this matter is very fundamental to resolving the petition. It is, my lady, this court that has repeatedly cautioned us that we should never attempt to resolve such a weighty matter as to who is the legitimate president of the Republic of Kenya on the basis of subterfuge. And I do pray, therefore, that you consider very seriously, my lady, that application, so that you may guide us accordingly. As regards time, we have another request. We are facing 7 petitions, and all these people are attacking the integrity of our technology, the capacity of our personnel, and above all else, the integrity of our chairman. We would ask for just 1 more hour so that we can meet these 7 petitions that have been allocated 10 hours. Thank you very much, my lady.
My lady, the President of the court and members of the court, I think the court has been very fair looking at the time allocation. We have 7 petitions, and in all those 7 petitions, we have been given a total of 6 hours with a little bit more time for the petition number 5. We have 3 hours. The respondents similarly have 6 hours. And I think that taking into consideration the time that you have to hear and determine the petitions, I think that the time allocation has been very fair. Otherwise, if you had to follow the arguments by my learned friends for the IEBC, you would similarly say that our petitioners had a lot more to lose than the other petitioners, and therefore we should be given a little more time. But I think in the circumstances, I think the court has given a fair consideration as to the interests of all the parties and how to accommodate all the parties. 6 hours for the petitioners and 6 hours for the respondents.
8 for the petitioners.
It's 6 hours. I think you do a little bit of mathematics, you're fine. Yeah. I did a little bit of mathematics. The other matter that I wish to draw the court's attention there is there are other pleadings that have been filed out of time without the leave of court. I would invite the court to look at those pleadings that have been filed out of court, out of time, and without the leave of court, to be struck out, because parties that have been served with these pleadings at the last hour would not be able to respond to them. And one particular affidavit which has been served, filed out of time, is the affidavit that on the face of it is by one Hilda Kavonga. That has been filed by the Electoral Commission, the first faction of the Electoral Commission. And at the last page, it says it's been sworn by Martin Wachira Nyaga. So some mutation, biological mutation, must have taken place. And that, I don't know how to crack that one. But the bottom line is that they've been filed out of time and without leave of court.
Yes, the Honorable Madam Chief Justice and the court, I have a small application that I thought I would bring to the court's attention. Due to late service of responses, the first respondent, the first petitioner in petition number E007 prepared responses and a further affidavit that were brought to the attention of the registry, but were rejected because of the question of time. In the same breath as my learned friend Professor Githu Muigai, who has not filed a response to an application by ISA, we would seek leave, Your Ladyship, to file the affidavit. It's a small further affidavit of only 44 paragraphs, which is as a result of late service, Your Ladyship, and submissions by the first petitioner in E007. Your Ladyship, in terms of representation, just weighing in on what my learned friend has submitted, Mr. Professor Githu Muigai, Senior Counsel, there are only 2 professors and Senior Counsel in court, the 2 of us. Why can't all of them appear for the IBC? All the Senior Counsel can appear for IBC, so that the court is richer with submissions from all parties, so that we hear the Chebukati faction and the Cherere faction, and I think the court then can make a good decision. Last, Your Ladyship, on the question of time, I just want to confirm that we only have 6 hours, like Senior Counsel Rengo said. And if my learned friend thinks that there are too many petitions, they can concede. That's all.
If may please, my lady, Honorable Chief Justice and my lords, on behalf of the petitioners in petition number 3, we were served in time by a set of documents from the IEBC. Then subsequently, last night, we were served with another set of documents from IEBC. Rule 11 of this court's rules are very clear on filing and service within 4 days. And we are greatly prejudiced if documents that were filed and served outside time does not allow us a rejoinder, and then those documents now constitute part of the record. We'll urge my ladies and my lords that when you consider the issue of representation of IEBC, please take into account that in respect to petition number 3, the IEBC faction, minority faction, served us with their documents outside time, and we had no opportunity to file any rejoinder. So that whatever they filed, we cannot speak to it.
Can you name the party who filed late?
It It was filed by.
Which was filed late.
It was served on us late. We were served last night by the law firm of GA and Company Advocates. And we received the documents under protest and did indicate. Our prejudice is we cannot file any rejoinder to all the issues they've raised.
Please repeat the particular document which was filed late and by who, which party.
My lady, I can speak to the service. We were served last evening. They are the first and second respondents' documents filed by the law firm of G&A Advocates. The response to the petition from the same law firm. There is a replying affidavit by Michael Ouma, filed from the same law firm. The first respondent's replying affidavit, filed by the same law firm. All those, and there's several volumes of volume 1, volume 2, and volume 2 of their supporting documents was served on us yesterday in the evening. And under Rule 11, they were meant to file and serve within 4 days of filing the petition. We have a 1 day to respond. We cannot respond to all those documents that they filed, and we urge this court to be guided by the case of Raila Odinga 2013, that late service of the documents on us has prejudiced us, and the information therein should be expunged from the record. That's all, my lady.
Thank you.
Sorry, my lady, if with the indulgence, I can also enumerate the pleadings which have been filed out of time. The first one is an affidavit by Oduor Juma Joseph, filed in support of the first and second respondents by G&A Advocates. This was filed on Monday at midnight. That is last night. The second one is an affidavit by Moses Ledama Sunkuli, and that affidavit has been drawn by the firm of Iseme, Kamau, and Maema, who are acting for the first and second respondents. This was filed yesterday, and it was filed out of time. The third one, again filed yesterday, is by the same firm of advocates, Iseme, Kamau, and Maema, for the first and second respondents, and it was filed yesterday. Affidavit by Balang Gideon. The fourth one is also filed, this was filed on Sunday, the 28th. This one is an affidavit of Catherine Wambui Kamau. And this one has been filed by, I believe, the same firm of advocates. This was filed on Sunday. The other one is an affidavit filed by the firm of Kithure Kindiki and Associates. This was filed today. And there's an affidavit, a further affidavit by Raymond Kiprotich Bet. The other one is an affidavit sworn by Martin Wachira Nyaga, an affidavit drawn by the firm of Iseme, Kamau, and Maema for the first and second respondents. This was filed on the 30th of August. This was filed today. Today at 2:45 a.m. The other one is an affidavit by Martin Wachira Nyaga, drawn by the same firm of advocates, Iseme, Kamau, and Maema for the first and second respondents. It was filed today, 30th of August, 2022 at 2:45 a.m. The other one is also an affidavit sworn by Hilda Kavonga, drawn by the same firm of advocates for the first and second respondents, Iseme, Kamau, and Maema, filed on Sunday at 11 p.m. And the last one is an affidavit sworn by Martin Wachira Nyaga, drawn by the same firm of advocates, Iseme, Kamau, and Maema, on behalf of the first and second respondents. This was filed on the 28th of August, 2022. And as far as we're concerned, they were filed out of time and without the leave of the court.
Your Ladyship, we may actually go into a wrong series of saying what has been filed late and only taking certain documents and not all of them. As I was sitting here, I've been served with a petitioner's further affidavit filed today. Today's 29? Filed yesterday, 29. And this is an affidavit that has been filed by the firm of Kinoti and Kibe Advocates. I think there is need now to take a stock of what has also been happening and which may not have been quite clear to the court. The e-filing system has had tremendous difficulties. And this you will confirm from the registrar, and I think all parties where we tried to file, we had challenges, and that took a bit of time. But to me, because we all look first at our own self-interest, the beginning point is the response filed by the firm of ISA on 26th August, and which takes the form of a new petition. That would be the beginning point, because if you are to allow that, then that petition will stand unresponded to date, because I could not respond to a petition filed outside the 7 days. So as you consider all these rival arguments, allowing some and disallowing the others, I think the most fundamental would be the status of that response, which is in the nature of a new petition. Once that is resolved, the other petitions in my submission would be dealt with quite easily. That is all, Your Ladyship.
May it please you, my lady, the Chief Justice of the Supreme Court, my lords, my ladies. On behalf of the first and second respondents, that is the chairperson of the IEBC, Mr. Wafula Chebukati, and the IEBC itself, I would want to mention just 3 quick issues in response to the issues that have been raised. The first, my name is Eric Gumbo. The first issue, my lady, is that just as has been indicated by Melanet Senior, Fred Ngatia Senior Counsel, the IT infrastructure of the judiciary and the portal upon which these documents are supposed to be filed had a big problem on Saturday. We did an email to the judiciary, got a confirmation that indeed the system was slow. And so that is the first reason why a number of documents came in late. Number 2, a number of these affidavits that have been alluded to before you this morning are affidavits that arose out of a response to affidavits that were filed by the same parties who are seeking to strike out these affidavits themselves. In particular, we got further affidavits from one John Gidongo. We got a further affidavit from one Arnold Ochieng. We got another affidavit from one George Joroge. And finally, one John Wesonga. These affidavits were filed way after the petition had been filed. They raised new issues. Specifically, they raised issues touching on the IT infrastructure of the IEBC. The most responsible thing to do, my lady and my lord, was for us to then do the affidavits. In fact, before they came in to raise the concern, we had ourselves wanted to raise this as a preliminary issue with the court so that we get directions. Because after we responded to the issues that they raised in their own further affidavits without leave, they again yesterday filed further affidavits seeking to now respond to the affidavits that we had filed responding to the issues they raised out of time. What is most interesting is that even in the affidavits that they filed as late as yesterday, they still raised new issues seeking to expand the 4 corners of the petition that is currently before the court, which then has the effect of making that petition mutate in form and character. Now, that said, my ladies and my lord, from where we sit, because of the significance of the issue at hand, we had taken the pragmatic approach to say that even though they served us late yesterday, that is late last night, we worked into the wee hours this morning and did our draft responses to those issues, so that if the court be minded to consider those issues, because I think some of them are pertinent to be able to go to the root of what we are dealing with, then those affidavits could be put in place. We be allowed to file those, the ones that we had not served, responding to the areas that they raised in the affidavits yesterday. In the alternative, that then the affidavits that they filed yesterday should be struck off, so that then we are not prejudiced ourselves. But secondly, and perhaps more importantly, because there is now no clarity as to which affidavit was filed in time, perhaps the best approach would be to ask the parties to file formal applications where they raise the concerns with specific documents, and we'll have an opportunity within this day today to demonstrate whether or not any of the affidavits was served out of time. I think that would give us clarity in such a way that no party would be prejudiced. I am most obliged.
Ms. Angumbo, those affidavits were cited by Senior Counsel Orengo.
Yes.
Mr.
Ngatia, sorry.
Mr. Ngatia, as senior counsel, you ought to know how to conduct yourself.
I do. With Chief Justice.
Affidavits which the Chief Justice has asked are not the ones that were enumerated by learned counsel, Mr. Orengo. They are the new affidavits that were filed and served yesterday are as follows. The first one is an affidavit by Martha Karoa, senior counsel, of 28th August and served yesterday. The second one also by Martha Karoa of 27th August and sworn on 28th, and we received it yesterday. Celestine Anyango Opio, sworn on 28th August and served yesterday. George Joroge, sworn on 28th and served yesterday. John Mark Githongo, sworn on 28th and served yesterday. Edgar Ouko, sworn 28th, served yesterday. Benson Wesonga, this was served yesterday. Yes, sworn 28th and served yesterday. Arnold Oshieng, 28th is the date of swearing, served yesterday. John Githongo, once again, 28th August, date of swearing and service yesterday. Those are the ones that prompted a fury of activity on our part to try and respond to them. I'm in the same position as learned counsel. We try to work very hard, but by the time again we try to file, the system did not allow us to file. So we have new matters which have been raised, which we have not responded to. May I apologize to my Lord, Supreme Court Judge, and thank you for reminding me yet again. I am sorry, the whisper was not meant for the court, but to learned counsel. Thank you.
My lady, the Chief Justice, you had asked a question about the specific affidavits. My learned senior, Fred Ngatia, senior counsel, has given the list of those affidavits. In fact, the ones that have been served on us are the ones from John Githongo, Arnold Ochieng, John Joroge, and Benson Wesonga. And my lady, I just wanted to mention that so that we are able to contextualize this affidavit, when we were served with the petition, we had a specific time within which to respond. We responded in time and served those responses. When the petitioners saw our responses, without the leave of the court, they filed further affidavits. Now, when those affidavits were served on us, we thought that perhaps instead of coming to ask for leave, we do the pragmatic thing of responding to them, then we come and have them formally, we get directions from the court on how to deal with them. Because it would have meant that we would be making an application for leave today to file in further affidavits. It also then means that if we are to get to the four corners of the petition, then we must get back to the first date in time. After filing our responses, what came up? The new affidavits. How do we deal with them? That would be the question. I had given a proposal that because some of them seem to raise a number of important issues, and we have satisfactorily responded to those issues, we could deem all those affidavits as properly served filed and served, so that then we forget about the side issues and go to the petition. More specifically, now that you have given us the issues that we need to be addressing you on. I am most obliged, my lady.
I'm sorry, this may be a back and forward, but there are directions which were issued by the court. This, I think, was on the 23rd of August 2022, and the directions required, if I don't go through all the directions, it required the respondents to file and serve their responses together with their written submissions and bundle of authorities on or before 5 p.m. on the 27th of August 2022. The petitioners then were directed to file and serve their rejoinder, if any, on the 28th of August 2022. So the affidavits they've been referring to, which were filed by the petitioners, were rejoinders to the affidavits they had filed on the 27th of August 2022. So looked at in that context, we were quite in order to file those rejoinders in terms of affidavits yesterday, on the 28th, not yesterday, 28th. And I think there was a further directions that there would be a close of pleadings on the 28th of August 2022. So that is the context in which I brought the question of the late filing of these or the affidavits I enumerated. As to the infrastructure of the court, we were in a similar position, but when we made inquiries with the registrar, we were told that if we had any problems with filing any documents online, then you could physically take the documents to the registry, and that's what we did. And there were absolutely no problem about it. In fact, because of those particular problems, in cases where we were required to file by 5 p.m., I think on inquiry we were told we could file the documents same day, but on or before 9 p.m. So I think the registry was quite helpful, and anybody who wanted to file a document within time, there were absolutely no problem at all insofar as the registry is concerned. But probably the court should look at all these documents, put them in context, and then make a decision. But our position is that the affidavits that I mentioned were filed out of time and without leave of court. We would need a demonstration that what we filed on the 28th was not in line with the directions that were given by the court.
Thank you. We are hoping we could bring this to an end so that...
Good afternoon, Lady Chief Justice, the Deputy Chief Justice and judges of the Supreme Court. My name is Mansour Issa. I am being led by Senior Counsel Paul Mwite. My ladies, my teacher, Professor, and my People Master, Senior Counsel, Professor Guido Mwegai, has alluded to the application that was filed by the firm of Iseme Kamau and Maema in the wee hours of yesterday. That application was filed on us at 3 in the morning, I think the first one. We had seen copies of that application on the portal before it was served, and we worked yesterday in the evening with the vice chairperson of the IEBC, to prepare responses to that application before it was filed. And when we tried to file the application today morning, the registry indicated they had not received the application that both parties have referred to. And indeed, Senior Counsel Kamau Karori has confirmed the hard copies of the application had not been presented to the court. So, my ladies, as you retire to consider that application, we have filed our responses online and would kindly request that the hard copies and the submissions that our clerks have presented to the court be considered because there was very late service, and I believe it's because of the difficulties with the e-filing. It was for quite a while yesterday down, but they should have sent us advance course, but there was no prejudice because we managed to see it in good time, as alerted by my learned friend, Ms. Joaquim Bosche. She was trying to file something. When she saw those applications, she called me. I was still reading, and we managed to file our responses to those applications. So we will abide by the directions given by the court because we had filed all our responses on behalf of the Commission as directed by the Commissioners. Thank you, and have a good afternoon.
My lady, if I may. My name is Kibe Mongai. I appear in petition number 8. I rise in order to speak to two things. Number one is that my learned colleague, Mr. Ngatia, has spoken about a petitioner's further affidavit that he claims was filed and served late. My lady and my lords, this further affidavit was sworn on 28th and served on them before midnight of that day, the Sunday that we were entitled to do our rejoinder. They were served, all of them. But more importantly, the affidavits of the IEBC and Mr. Wafula Chebukati were served on us on Sunday at noon. So that there was a question of the time when our 24 hours was going to run. But despite all that, we filed the affidavit on time and served, but we could not be able to file because there was a problem, and we were told, and the following day when we presented document and we explained, they were admitted, so that is only referring to the issue of the physical copy. And the original trigger was by IEBC. But we decided not to break bones, and we've not said IEBC served us with anything late. It came on Sunday, and we responded. And therefore, as far as we are concerned, the only issue that we did yesterday, and we filed, but it requires that just to be submitted to the court, are our submissions. But they were still done within the 24 hours, but the system was down. We were told as soon as it is there, file it, and then present. So that as far as we are concerned, all our documents are in place and filed on time. Having finished with that issue of petition 008, it is my hope that no directions may have been given without me getting to know of that issue. But the court will note that there has been correspondence between my office and at least with the registrar with regard to petition number 22, E025, between Kenneth Jage Jiro and 10 others versus Honorable William Samoei and Honorable Rigathi Gachagua. May the court note that that petition that was filed on the 5th of August this year relates to the issues of the validity of the nominations of Honorable William Ruto and Rigathi Gachagua.
Yes, with utmost humility, Mr. Kibe, we are dealing with Article 140, matters that arose from the dispute on whether the president-elect was validly elected. Those matters were filed before the elections and before the declaration. So you wait for the ruling, it will be delivered.
It will be delivered.
It's a separate matter from what we are dealing with. So let's not go there.
It's okay, my lady. I'll go by that. Thank you.
We want to bring this to an end on the three issues that have been addressed to the court.
With your kind permission.
That is the time allocation, the presentation of the two factions of the IBC, and the documents that have been filed in court with or without leave of the court. The court would wish to adjourn to consider those matters and resume at 3:30. I will also kindly ask the parties to furnish the registrar with those documents because documents have come, so many documents have come, so that we can be able to look at them and deliver our further directions at 3:30.
I'm also obliged, my lady.
Because we are just going around the three issues. The three issues of the time allocation, of the documents filed, which were found late, which were found without leave. Allow us to go and consider that, and the issue of representation.
Yes, my lady. Just one item, my lady, which...
You can't be addressing the court, two of you.
Yes. My lady, with your kind permission, my name is Kamau Karori, Senior Counsel. My lady, I just needed to comment on just two issues. The first is the allegation that the application that was filed to strike out the name of ISA and company advocates from the record, that it was not, the physical applications were not presented. The correct position, my lady, is that they were presented, but we were informed by the registry that in view of the fact that the court was sitting today, that the appropriate thing to do would be to come and seek leave of the court before the documents are received at the registry. So it is not true that we did not serve those documents. Secondly, my lady, regarding the documents, there's also an important point, my lady, to point out, which is that the affidavit filed by John Githongo, he had filed a response first, then he filed a further affidavit out of time, and in that further affidavit, he introduced completely new documents. In fact, as you will notice when you retire to write your ruling, he now withdrew the initial logs that he had attached to his affidavit and filed completely new ones after we had responded to his previous affidavit. The only option available to us, having been served with these new documents, was now to respond to them. You'll also notice, my lady, that the documents filed by Arnold Oginga, again, they are completely new documents from the ones that had been filed earlier. The prejudice is, on the basis of the document that had been served upon us, we had already responded and filed submissions because our time for filing submissions was very limited. Now we have a situation where new documents have been filed. We have no opportunity of responding to them in submissions because our submissions have already been filed. The only option was for us to file an additional affidavit explaining or answering these new documents and assertions that had now been made. And that is why the documents that were filed out of time on account of the system issues that my learned friend has alluded to. Thank you, my lady.
Thank you.
With your permission, your ladyship, my lords, mine are separate and different issues. The first one relates to the orders you made for scrutiny this afternoon.
Please, can you introduce yourself?
Yes, my name is Katwa Kigen. For the first petitioner, together led by by my senior, Mr. Ngatia. It relates to
respondent, you mean?
Yes, first respondent. I apologize for that. It relates to the issue of scrutiny that is supposed to start this afternoon. We would like to request that the court takes on board consideration of the issues of security, considering what happened at the National Tally Center, my lords and your lordships. And we would also like that the issue of the location where it is to be done be addressed. And we would prefer, considering the security issues also, that camera surveillance be addressed, my lords and my ladies. The second issue, my lords and my ladies, is you granted permission to the Attorney General to introduce two affidavits, and we would the two affidavits introduce very substantial facts that go to the touch very seriously on our case, and we would like and pray for leave to respond to those affidavits, considering that you've allowed them in. Thank you, my ladies and my lords.
My lady, the Chief Justice and judges of the court, my name is Charles Kanjama for the ICT professionals who've been admitted as amici. I have also two requests to make to the court. One is that in respect of the scrutiny that will be taking place, that the amici whose assistance to the court is to give independent observation of the election technology, be allowed to participate and also be allowed thereafter to prepare and present their own independent report so that they can effectively assist the court. Second, in relation to the technology affidavits that have been filed late in the last 2 days, the Amici, in their initial report, had responded to the initial technology affidavit so that they could give an independent perspective from ICT professionals who would request that they also be granted leave so that they can supplement that report by also responding to the subsequent technology affidavits which this court is considering whether to admit. That is all.
My Lady Chief Justice, my name is Mituga. For the petitioner, in petition 004, I also have a problem of experience by the rest in filing documents when there was a system downturn. Our rejoinder was supposed to be filed on 28th, but due to system problems, although we filed our set of documents serving as a rejoinder, we presented them to court yesterday. When they were stamped as filed out of time, in considering the rest of the document filed out of time, we asked the court also to consider the fourth respondent's document, supplementary submissions, the supplementary affidavit, and list and bundle of documents dated and filed on 28th of August 2022.
Lordship, why, in view of all these counter arguments, the petitioners, respondents, filing late, claiming, Your Lordship, if the court could just give us 1 hour to regularize so that no party then excludes anything from the record, that would serve the interest of justice. And I submit, Your Lordship, that then no party will feel that they've been locked out. So we don't go back to Raila 2013, where huge documents are locked out, and we will find fairness in this court.
Thank you. You know, our time is not elastic. There was an order for scrutiny from 2 p.m., so we really have to adjourn now.
I just wanted clarity on the role of the Amici. It would appear that they want to go beyond their role.
Senior counsel, we will deal with that. We are capable of dealing with it. We already gave directions that we will rely on the Amici brief that is already on record. Rulings have been issued to that effect. And we will reconvene at 4 p.m. because of the many issues that have been raised.
Tumeweza kufahamu zimejumuishwa pamoja kuweza kuanza kusikilizwa. Jambo la muhimu likiwa kwamba kwa sasa hivi mahakama imeweza kueleza mambo ambayo itakuwa inachunguza ama kuweza kusikiliza ama yapewe kipaumbele katika kesi hii, ikiwa ni pamoja na iwapo teknolojia iliyotumika wakati wa uchaguzi mkuu ilikuwa yenye kuleta uhaki, usawa, na vile vile yenye kuweza kuhakikisha kwamba kuna njia za kuthibitisha, na vile vile kuna vyombo vya usalama ambavyo vileweza kutumika katika kuwasilisha uchaguzi na hatimaye kura zilizopigwa.
Naam, bila shaka, na baadhi ya mambo pia yakiwa yanahusisha iwapo kulikuwa na hitilafu ya kuingiliwa kwa fomu 34A pamoja na kama kulikuwa na tofauti kati ya zile fomu 34A zilizokuwa katika mtandao wa IEBC, zile zilizokuwa katika kituo cha kujumlisha kura cha kitaifa pale Bomas, na zile fomu zilizokuwa katika vituo vya kupigia kura. Nadhani masuala haya yote tutaweza kuyazungumzia zaidi. Tupumzike kidogo tupate matangazo ya kibiashara, kisha tutarejea na taarifa zaidi wakati ambapo mahakama ya upeo imesema